Yeah, what's going on here then? Really run me through it, because I was amazed that it wasn't criminal damage to begin with.
Yeah, so in June 2020, many people remember that at the height of the Black Lives Matter protests, protesters in Bristol toppled the statue of slave trader Edward Colston and threw it into the Bristol harbour. Now, many of those involved in the protests were charged with criminal damage. 6 accepted a police caution, but 4 were acquitted following a trial by jury. And what was particularly striking about the case was the arguments that the defence lawyers had used in order to defend their clients. So one of the arguments, for example, was that following the campaigning that was done to remove the statue in years prior, the refusal by Bristol to remove the statue essentially amounted to a hate crime. So the judge allowed the defendants to essentially expand the boundaries of the arguments used to defend them. And also another argument that was put forward by the council was that, for example, it cost a lot of money, all of the criminal damage that was accused. But the arguments that the defendants said that was actually following the removal of the statue from the harbour, it appreciated in value, meaning that actually it didn't necessarily cost the council a lot of money. But the third argument, and this is the one that I think has caused a lot of controversy, was essentially the argument that it potentially was disproportionate to charge them with criminal damage because it may amount to a violation of their right to protest and freedom of expression in relation to pushing back against what they argued was a racist statue. And this is the argument that caused controversy and led to Suella Braverman, the Attorney General, to refer this particular case to the Court of Appeal because she argued that it led to uncertainty in relation to the range of arguments that could be used as a defence when it came to criminal damage in relation to a protest. So this is the referral that is taking place, and this hearing is taking place over 2 days to really clarify the points in relation to what the arguments people can use in relation to criminal damage.
Yeah, I was quite surprised, well, very surprised actually, when they were found innocent. I mean, I think they were just a bunch of white hippies trying to speak for black people personally, which I didn't agree with. But I was confused more specifically about why it wasn't criminal damage. Yeah. This review, this appeal, won't necessarily retry them. It can't under the law unless new evidence is presented. So what's the best case scenario here for Suella Braverman? What does she want to actually see these judges say?
Well, the Colston Four, many of them actually accepted that they had damaged or enacted behaviours that many people would regard as unacceptable, but whether or not criminal damage as a charge would be proportionate in relation to their right to freedom of expression and the right to protest. And it is interesting, I had spoken to Laura O'Brien, who was a solicitor that defended some of the Colston Four, and she argued that Suella Braverman's acts were essentially political overreach and that she was essentially just unhappy with the decision that the jury made, which is an essential pillar of a democracy. And Laura O'Brien also argued that, for example, that we have to understand what Suella Braverman is doing in the context of the Police Crime Court and Sentencing Bill and the restriction of the right to protest. But obviously the Attorney General would push back against that, and she has argued that this is really trying to clarify the scope of arguments that could be used, as she worried that this would set a precedent for future cases where there are similar arguments being made.